Hello and welcome today, Johann Soufi. I'd like to begin by thanking you for taking the time to come and interview with the Cambridge Journal of Law, Politics and Arts to provide insight and thought based on your extensive experience as an international lawyer. As you have worked in prosecuting and investigating international criminal and human rights violations, and having been counsel for various international tribunals and courts, such as the ICTR, STL, or the ICC, I wanted to begin by asking you what prompted you to delve into a career in international justice, as opposed to concentrating on domestic criminal law.
For the question, and thanks for the invitation first. I don't think there is a big difference in the essence of what it is to be a lawyer in the domestic or the international system. I think, when you're interested in criminal law, you're interested in understanding why some people commit some crimes and what basically is a human aspect behind these crimes. So in that respect, to be honest, I could have practiced in France, where I'm originated from, or at the international level. But really what I was interested is understanding also, the diversity of the societies and of its impact or their impact on the crime that we see. And obviously there was also an interest in the scale and the unfairness of some situation beyond Europe. And I think as every practitioner who wants to practice human rights or international criminal law beyond the domestic system, that was also the extent of the suffering that we've all noticed, that I was interested in addressing.
And as there are many cases I'm sure that you have to discuss from, I was wondering if you could please give us an example of a case you worked on to help establish the state's accountability for their human rights violations, and ultimately this resulted in justice being realized for the victims.
Well, state, I don't know, as you probably know, international criminal law is about individual liability. So the idea behind ICL is basically that behind a crime, there is not like a generic state or population. There are specific individuals who commit crimes, and that this has an impact on an entire society. So in terms of judging state, perhaps I would not have an answer, but I would take two examples, which shows also the diversity of the accountability mechanism that they are. The first one will be my work for the Commission of Inquiry in Mali, because we had a mandate from the Secretary General to address all the crime from all the parties, governmental, non-governmental, and also international forces of the human rights violation and crime that took place in Mali. And the reason why I take this example is, as you've seen, currently there is a strong pushback from the regime in Mali against anyone who is interested in human rights. And that could be a bad sign, but I think also what's interesting in international justice in general and human rights accountability is to be patient and to see perhaps the result of a work, perhaps not today, but in 10 years. So that would be the first example. The second example I would take is perhaps my current work in Ukraine. I work as a senior prosecutor for a foundation that assists the prosecutor of Ukraine in fighting impunity for the crimes committed by Russia. And it's the same. There is much more perhaps political desire right now and a strong push to fight impunity for the crime that takes place in Ukraine. But the reality of this political motivation and of the accountability mechanism that are set out right now in Ukraine, we'll see that probably, in 5, 10, 20 years. So I don't know if that answers your question, but it's just to say that, with every work we do as international practitioners, we'll see the effect of that sometimes 5 years, sometimes 20 years down the line.
That definitely answers my questions. And I think if anything, that stems into what I want to lead into the next topic. But I think from what you've just explained from your experience, it demonstrates how international criminal law and international human rights law are the fundamental basis for the international community to be able to legally step in into another state and hold, as you just said, individual actors accountable for the most serious crimes. And when we see these gross human rights violations occurring around the world, these legal mechanisms truly provide hope for addressing these issues. But equally, various challenges do come across, and that's what I kind of was hoping to stem into now, beginning with Rwanda. So reflecting on the ICTR and the acquittal of Justin Mugenzi and Prosper Mugurianza, this, among other various instances, demonstrates the difficulty in proving responsibility of political leaders for violations of international human rights law. And on the one hand, we must abide by the rule of law and not assess the innocence of an accused, but rather determine their guilt beyond a reasonable doubt based on the evidence that is presented. And this is the case in various criminal law jurisdictions. However, establishing evidence is very challenging in the international sphere. So from your experience, how is this something that we could address?
I don't know if you've seen in my profile, but actually my first work in Rwanda was for the defense. And the reason why I say that is that as an international practitioner, I've been always interested in the process rather than in the result. And so, for example, I don't see acquittal, including of, high-level political leaders, as a failure of the system. I see it sometimes as a failure when the prosecution or judges actually failed their mandate. But I see that sometimes also as like just an efficient system, like in the domestic, in domestic criminal trials. Sometimes you have an acquittal just because the person is innocent. And so that's also, I think, what happens, what happened at the ICTR. The second thing I think, which is extremely important, is especially in this international context, you have to understand that there are strong political stakes. And so that the right of the accused and the fairness of trial is even more important, because you cannot be sure at the beginning of a trial that there is not also, political motivation behind the trial. This said, you're entirely right. International trials, and especially when they are targeting, senior commanders in the military or even more political leaders, are extremely challenging. And the reason is that the people who are behind the crimes, the most responsible, are usually very far from the crime scene. Usually they don't have blood on their hands to say, to take a physical, but they are very responsible because they are the one behind the planning, behind the organizing of the crimes, and the crime would not take place without their involvement. The problem is, and to take another example, that's going to be like a mafia case or organized criminality in the UK. It will be very easy to arrest the person who sells drugs or the person who committed a murder. That's going to be much more difficult to know who is at the top of the pyramid, to take an example, and to understand who's the mastermind behind the crime. That's true also for international crimes, because most of the time when you talk to victims or witnesses, they tell you, well, I can testify of who I've seen committed this crime, but I have absolutely no knowledge about who is behind the planning. And actually, usually when you have someone telling you that they know who is behind the planning, that's even, for me as a practitioner, that raises concern about the credibility of the statement, because usually to find out about common responsibility or, like senior leadership, you need to conduct long investigation, have access to insiders also, which means people within the group who have committed the crimes, who testified about who they received orders from, where they received the money from, perhaps have access also to telecom evidence, conduct, intelligence analysis, so have a much longer and more difficult investigation than just, interviewing few witnesses and figuring out who is the direct perpetrator behind the crime. It's much longer, it's a much more complex process, and that, if it is not well explained, can create frustration among the victims and in general among the international community about the length and the outcome of certain trial, like the one you mentioned, the ICTR.
Just following up on a few points that you said from that, because I think that's very well said, in the sense, because of course in these circumstances, I think when there's issues of human rights violations, I think the general consensus in the public is very quick to point fingers at the state actors in question, rather than really considering the implications, as you said, that it's not a matter of the result, it's the matter of the process. So the same way in a domestic sense that we would have a trial and due process, that's also the expectation in the international implications. And of course, as you said, that there's a lot of, there's higher political stakes. So equally, we have to be very careful with how we prosecute these crimes and establish accountability. But equally, from what you've just said, it does sound like a very difficult process in terms of the investigative process that goes into it, and gathering the evidence and speaking to the witnesses. So in terms of balancing between, the political stake, but then equally also ensuring that it is still possible to establish accountability and establish that link to the perpetrator and the planning that were behind and the violation. Do you think the current international criminal law framework that we have in place is appropriate to address this? Or is it a matter of potentially reducing the burden for the prosecution currently?
Change the burden of proof. I mean, to follow up on what I've said, when you want to know if a state is democratic or respect human rights, it's paradoxal, because what do you look at first? Yeah, the right of the victim, but mainly the right of the accused, right? To know if a system is democratic, what you actually should examine first is the way states treat the suspects. Because, what I've seen in a lot of the situation where I've considered human rights violation, usually the first violation, there are false accusation of terrorism against the state, etc. And so the first indicators of a more, perhaps a wider form of violence against the population usually starts with the right of the defense and the burden of proof. So I think that if the international community wants to be credible about, promoting human rights and international law, they should always abide by a very strong burden of proof and presumption of innocence. So by all means, not changing the burden of proof. What they can do, though, is a bit more awareness of the difficulties on the field. What I've noticed sometimes in international trials is that judges, prosecutors, lawyers alike, are in a form of a bubble. They're in The Hague, conducting their trial or their investigation, and they don't always understand the reality on the field. The pressure that the state would put on the witnesses, like the threat to the life of witnesses. Also, the possibility that, a witness 20 years later, after years of trauma, would not remember the color of the car of the accused or the precise date of when a crime took place. These are very important cultural elements that I feel sometimes international practitioners forget about, and then assess the credibility of evidence with a lens which is not adequate. So my answer in a nutshell would be, by all means, you don't touch at the burden of proof. That's the pillar of any democratic system and of the legitimacy of international criminal law. But yes, you should also look at the evidence with a bit of better understanding of what it means to, to witness such crimes and to actually investigate in such difficult context, where sometimes the entire establishment, the entire forces of the state are acting deliberately to prevent you of finding out the truth.
That's a very helpful insight. And I think instinctively, I did suspect that that would be the answer as well, in terms of not touching burden of proof, because I think no matter how difficult it is, the implications of what it means for the justice system, it would be too much at stake. I now wanted to transition a bit to focus on broader issues occurring on Africa in terms of human rights violations, especially in the context of the journal, because we speak with various human rights abuse survivors, stemming from all sorts of issues such as child soldiers, sex trafficking, mass starvation based on a political tool from the state. And we were wondering, from your experience and your knowledge as well, beyond the ICC, how are we able to provide relief for them, or are there any legal mechanisms we have in play to sort of address these crimes outside of the political sphere?
I think, Africa, in a way, has been at the forefront of the fight against impunity because of the scale of crime that takes place in this continent, but also because, the international community and African civil society has been really creative in finding ways to fight impunity. Of course, we talk about the ICTR, which came from the UN Security Council, and we can talk about that later. But a lot of other mechanisms. I mean, I've worked for the Special Court for Sierra Leone. The idea of this court came from the Sierra Leone government under the pressure also of Sierra Leonean civil societies. You have also, domestic trial in Senegal, for example, for the extraordinary chamber for UNRWA. You have also, truth mechanism in Gambia, in Liberia. You have currently a court in Central African Republic, which is a court of a hybrid nature. So you see, there is a wide range of accountability mechanisms which are possible beyond the ICC and beyond, international tribunals created by the Security Council. And I think that really Africa, in a way, has been probably the continent where the range of accountability mechanism and the legal creativity has been the greatest.
Thank you for that explanation. That's very helpful to know. I now wanted to transition to speak about the creation of the STL, established after the assassination of the former Prime Minister Rafik Hariri and 20 others, which was the beginning of a fight against international terrorism, even a first step towards the responsibility of perpetrators of serious violations of human rights in the Middle East. I was wondering if you could speak a bit about the types of investigations, as you touched upon earlier, about how difficult and challenging this process is, but reflecting on this experience particularly, what was required to be carried out in Lebanon when you were working as counsel?
When I was talking about complexity, of international law, I mean, you have to remember about the context of the creation of the STL. It was a tribunal which was requested by Lebanon, but due to strong political division in Lebanon. It was not possible to be established following an agreement between Lebanon and the UN. So the Security Council took a resolution finding that the assassination of Hariri was creating, a threat to international peace and security, which was controversial to say the least. The fact also that we had trial in absentia was extremely controversial. So already the STL, suffered from a form of crisis of legitimacy at the beginning. There was also in Lebanon like a strong opposition to the work of the STL, which was seen as a interference or as a political move against a certain part of the political parties in Lebanon and especially Hezbollah. So yeah, it was difficult. It was a difficult context. And if you add to this complexity the nature of the crime, I mean, whoever carried out the assassination of Hariri was extremely cautious in, erasing any trace of link with the people who ordered the crime. So the investigation for the prosecution was extremely complex, relying mainly with no witness available, so no insider, as I was saying, no financial trace. So it relied exclusively on telecom evidence. And, a very, very complex investigation into circumstantial evidence, only based on call data records. And so that was, almost the first form in the international criminal justice of a case using only modern technology. No witness, very few investigation on the crime scene, but mainly, a case of analysis and complex analysis of circumstantial evidence.
And following up on that, at the end of the proceedings, in the end, the trial chamber judges unanimously found the guilt of Salim Ayash, yet acquitted 3 others, alleged members of the Shia organization, due to the requirement of the high standard of proof. But from your experience working in the STL, do you have any reflections in thinking back on the end of the trial, what could have been done differently throughout the process, or particularly in the prosecution side, sort of what can be taken forward?
First, just to complete your question, the appeal chamber later overturned the decision of the appeal chamber and actually convicted all the accused but one to life sentence. So eventually they were all convicted but one. I think when you ask the question about what went wrong with the process, there were strong criticism against the STL, and some of them, and I think a significant part of them, are also justified. The STL was a bit disconnected from the community, the Lebanese community in general, and what was initially requested by Lebanon and the Lebanese population quickly became, an object disconnected from the field. And what I mean by that, I highlighted before the complexity of investigating in Lebanon. I mean, the real genuine security threats for anyone who would cooperate equally with the defense or with the prosecution. So there were significant, political and security issues for the STL. But in general, the way the evidence was seen by the judges, by the defense, by the prosecution, the way the case was treated was more, I would say, from an international lens. And as I said earlier, a bit disconnected from, the daily or not even the daily, from the legal, from the cultural culture in Lebanon. And so people in Lebanon quickly got a strong disinterest for these proceedings. And eventually the STL was lacking the support it needed to continue its activities.
Thank you. And following up in terms of some of the challenges that took place, a big question that also came out of it was the difficulty with the funding. And particularly the SLT funding model was, I believe it was Lebanon to meet 49% and the remaining states to meet 51%. Are there alternative ways that we could consider to provide funding in order to enable access for justice in such circumstances in the future when we want to continue setting up special tribunals?
Yeah, actually, let's put that again into context. My wife is Lebanese, so I'm very aware of the difficulty of the Lebanese population, like the huge financial crisis that is hitting now in Lebanon. I mean, I started before. So when the Lebanese people contributed, as you say, to 49% of the budget, for the population, it meant something. It meant that out of the perhaps $60 million per year of budget, 30 million came directly from the Lebanese, taxpayer. So that has an impact. And I think that, some justice, and we can talk about that also later, justice costs money, which is nothing compared to also other amounts that are sent, that are used in the world for other purpose, war, or in the finance, etc. It's pocket money, but it still costs a lot. And I think that we should never forget that we should be more efficient because these courts cost a lot of money, and also political priorities might change. And that's the nature of the international environment we are evolving in. And so it's extremely important that, in addition of finding funding for our courts, we also always aware that, we are competing against other crises. So for example, right now, Ukraine is at the center of a lot of discussions, and significant funds are attributed in Ukraine. That is sometimes detrimental to other crises in the world. And so, yeah, I agree with you that it's extremely important to find as much sustainability to international justice as we can, with a regular budget like perhaps what the ICC is trying to create also in terms of funding. But we have to be aware also that we're evolving in a political environment where, the funds will always come from states, and states have political priorities. And so it's important to always be aware that funding of international justice is going to be always kind of, precarious in that respect.
Makes sense, thank you. And just to kind of continue reflecting on what you've said earlier, as we know, there were good reasons for establishing a court. The least of them certainly being that in the face of the absence of the Lebanese people's own trust in the judiciary, an international tribunal was established. I was wondering if, stemming outside of Lebanon, but also looking to other countries in the Middle East, is there scope for other tribunals to be established in countries such as Syria, Iran, Saudi Arabia, where we see various conflicts occurring still to date and a violation of human rights?
I think, again, I will just highlight the strong link between international criminal justice and, the political environment. I mean, we all know why there was no tribunal for Syria or for the crimes that are taking place in Palestine or in Saudi, in all the, in all the situation you've mentioned. It's because of political deadlock, either at the regional level or at the international level, with the veto at the UN Security Council. This is a reason why there is perhaps at some point a tribunal for Lebanon and not a tribunal for Syria. This said, I think, international practitioners, diplomats, we're trying to be creative in the way we address these issues. And so, for example, for Syria, you know that there is a mechanism in Geneva collecting the evidence, serving as a central repository for the evidence, and then sharing it with national jurisdiction. And that's why also there were prosecution and trials against Syrian individuals involved in crimes there in Germany, in France, with the assistance of this UN mechanism. You have all the possibilities. You have also, so of course, universal jurisdiction. You have what they're also trying to establish right now for Ukraine with hybrid courts, or with a EU court, or like a hybrid mechanism, a general assembly mechanism. So basically, we have almost endless possibilities, but I think the key behind everything is political willingness. And, political willingness, at least in democracies, come also from, from the field, from the people. So that's where I think, awareness, information about what's happening in the world is extremely important, because that's when people are going to be aware of the human rights violation, worldwide, that they will push for more accountability. And then that governments, at least again in democratic systems, will push also for similar mechanism, or even economic sanctions is also a tool that could be interesting. So yeah, I think the advocacy, by people like you, by practitioners, by human rights activists is extremely important, because that reflects on the general population, which later hopefully can reflect on their government.
Out of curiosity, one of the points that you touched upon with respect to the Security Council, because quite obviously that's not going to be an option with the permanent veto from certain states such as Russia and China. But do you see, for instance, a prospect for to go sort of beyond this, in the sense that the General Assembly, for instance, issues an advisory opinion from the ICJ? Do you think that would be a potential solution, or has prospect of sort of providing that political willingness that you were talking about?
It's also a mechanism that that I forgot, and that you emphasize, which is important. I think, well, although it's just advisory opinion, but it's still like you have a UN court, making a judgment about sometimes, situation like the war in Palestine, for example. I think this has also, a lot of legal power in a way, because you have a UN court setting what is the law. That's extremely important. So yeah, that's definitely a path. And I think a path also is for the General Assembly to, to be more empowered in, in taking action, because let's face it, the Security Council is a political body that which is inherited from, a time which is kind of outdated in a way, but you cannot reform the Security Council without, without members of the Security Council agreeing for that. And the UN is still the best solution and the best tool that we have. So we have to be creative with the tools that we are given, and to explore all the possibilities for the international community as a whole to go beyond the possible the possible deadlock of few countries, and I think, and the veto. of the P5, and only few of these P5. So yeah, that's important indeed.
That's very helpful to further understand as well these mechanisms.
And I think, if I can say, the Rome Statute is a perfect example of that. I mean, some countries thought, well, actually, we cannot wait for the UN Security Council to always create ad hoc tribunals for each situation. So you know what? Let's create a new treaty-based jurisdiction, which hopefully one day will be universal. At least it's permanent, and state will join. And I mean, the mere fact that today you have 123 countries joining voluntarily such a court is also, I'm always a kind of half full glass man, but that's something quite impressive, in the course of the last 30 years. So yeah, I think in terms of creativity, even beyond the UN, we can be also creative in, pushing agenda for new courts, even on a treaty based treaty basis. So yeah.
Yeah, no, absolutely. And I think as you've just summarized the prospect quite endless in terms of to strengthen. I wanted to continue discussing one more point in terms of your work in the Middle East. And then particularly your experience from on the STL. This goes in respect to the definition of terrorism and attempting to define it, well, defining it in the international sense, but also the implications that have come along with it. Particularly, for instance, when looking at the definition of terrorism being assessed in more of the domestic criminal process, such as, for instance, Paul Rusesabagina, Rwandan opposition leader, was sentenced 25 years in prison as he was said to be guilty of terrorism. Then equally in the United States, you have various issues with the claim of terrorism being labeled on individuals, and that ultimately prevents due process in the trials, particularly in circumstances of the Guantanamo Bay detainees. I was wondering of your outlook of describing the definition of terrorism, particularly in experience of the international law sense.
Yeah. Yeah, I think, you highlight an issue that I've thought about. Even my master thesis was on the definition of terrorism. So that's something I've been interested in for a long time. And, being also Franco-Algerian, I know that my two countries have suffered terrorism. So that's something which I think is a very important topic. On the other hand, you've also highlighted perhaps, and we can take all the countries which use the definition of terrorism, against any form of political opposition. So that's why it is a hot subject, a hot topic, not only at the international level, but also at the domestic one. But to discuss what is more relevant to your question, I think that's one of the adding value of the Tribunal for Lebanon. I mean, they've tried to think about what could be a universal definition of terrorism, and they came up with a definition which has just the value so far, just like a legal value for the purpose of the STL, but that's an interesting development. I think, the main issue here is not a legal one, it's a political one. And it can be summarized in 2 points. Is there state terrorism? And do armed group fighting for freedom against colonization or occupation fall within the definition of terrorism? I think these are the 2 elements which are creating legal tension. And that's why, despite 20 years or even much more actually, years of work at the UN level, there is still not a universal definition of terrorism, not a convention on international terrorism beyond specific convention for the aviation, for access to nuclear facilities, etc. So that's my answer. My answer is that it's not a legal issue, it's mainly a political issue, and I understand why. But to complement perhaps this answer, I would say that do we really need, do we need an international definition of terrorism? I think from an ICL and IHL perspective, you have already a lot of tools. You have war crimes, crimes against humanity, which applies both in terms of, in the context of armed conflict and also outside armed conflict, that you could have situation which you would qualify as terrorism, which fall within this definition. I think at the domestic level, you have every state, I think, almost in the world have a definition also of terrorism. So, you have already legal tools that can ensure that some of the aspect of the criminality that you're describing is already, addressed with legal mechanism. I agree, though, that it's important for the international community to continue to work on this issue, because terrorism, especially modern terrorism, is per se a global issue, and so global issues require global answers. And so the UN or international instruments are the best way to address that. But as I said, that's more a political discussion than the legal one.
Yeah, no, absolutely. And I think you addressed various key issues in terms of finding the definition for terrorism. And I think if we even reflect back on history, it is such a complex definition, because there was a time when George Washington was considered a terrorist, or Nelson Mandela was considered a terrorist. So it's an evolving definition, and I think it's a very tricky to pinpoint. And with that, based on what you've just said, because of this complexity, do you think, based on how you said, we already have certain crimes under international law where what we're trying to accuse an individual under terrorism would fall under those crimes nonetheless? Do you think there's still an ongoing need to find a definition for universal terrorism, or in terms of what is currently taking place as quote unquote terrorist attacks in various countries could still be held accountable under the other crimes that we already have in place and are much more concrete to pinpoint under definitions, legal definitions we have?
I think, at the domestic level, honestly, there is rarely a difficulty, except in respect of human rights, etc., and the right of the accused. So, because states are always very interested in fighting domestic terrorism, right? So this is, I think, a non-issue. It's more important, I think, at the global level to also, tackle issues such as financing terrorism, state support of terrorism, access for terrorist group to certain chemical or nuclear weapons. These are, I think, pressing issues which, there is not always the same kind of level of response. But in terms of domestic law, I think an emphasis should be actually in ensuring that, terrorism is not used as a kind of, umbrella to prosecute any form of kind of domestic opposition. And I think the UN is also working on that in these two aspects, including the CTED, the Counterterrorism Executive Directorate, and also UNODC, etc. So you have already a lot of responses. So yeah, I think that's basically the kind of avenues where there should be also a lot of emphasis. And of course, if we can come up with a universal definition of terrorism, that would be great. But first, we have also to address some kind of specific situations where this going to create a political issue. And just to give you an example, when I told you I was working for the Commission of Inquiry for Mali, and even in the UN, some groups were qualified as terrorist group, while others were qualified as armed group. And, from an IHL perspective, terrorist group would be people who terrorize the population, but this can be done equally by groups which are considered, let's say, terrorists, so such as Al-Qaeda or Daesh, but also by, independentist groups who are also terrorizing the population. And so I think that from an IHL perspective, it's much more, legally accurate and interesting to stick to the Geneva Convention and to see what are these armed groups doing against non-combatants and how they're applying, the jus in bello and the jus ad bellum. So I think that the IHL instruments, in a way, are much more legally correct and also, impartial, and already provide us with a lot of legal tools to address some of the crimes that you have described.
Yeah, no, and I think that makes complete sense. The reason I also ask in particular, because I think this is more relevant in certain countries than others, but when you have the label of terrorism, then it sort of shields the state from doing away with justice and due process and sort of having an excuse of trying the perpetrator or alleged perpetrator without the due process you would normally have in other certain crimes. And people are much less quick to question it because of that label, terrorism. And this goes particularly in respect to some of the research that we've been doing in respect to the United States, beyond Guantanamo Bay, but in general, when individuals are accused of terrorism. There have been various instances where there was a lack of evidence against them. It was simple things such as financing a group in Palestine, but immediately it was they were charged, and things occurred during trial where expert witnesses weren't allowed and their counsel was not allowed to cross-examine, which would never happen under the Constitution. So it's just one of those where it's great to, well, not great, but it's important to have that crime of terrorism, as you just touched upon, because it won't necessarily be encompassed under various other criminal tools that we have, but then equally the enforcement of it, or the I suppose the usage of it could be quite dangerous in countries that have a bit more stigma and are a bit more relentless to use it as in their favor. But that's very interesting, I think, nonetheless, to also consider in the wider context of what you've just said. That being said, I also wanted to continue speaking in terms of Palestine, and particularly about your role in the UNRWA. I was hoping if you could share a few reflections you made when you were working in this field.
Oh, sorry, can you repeat the question? I'm sorry, I did not hear. About UNRWA?
No problem. Yeah, I was wondering if you could tell us more about your role in the UNRWA and share a few crucial reflections you made when you were in this field.
Yeah, well, my work in UNRWA was a bit different from anything I've done previously in my career, in the sense that, UNRWA is much more, not much more, almost exclusively focused on, providing humanitarian relief. And so not doing the human rights and ICL work that I've done in my career before that. But that gave me, I think, also, a better vision also of the needs of people beyond justice. I mean, justice is extremely important for the Palestinian population in Gaza, who has been suffering, decades of human rights violation and abuses. But they have also pressing needs for food, for education, for health. And UNRWA has done an incredible work in providing these services in the absence of, of a state providing this form of service due to the political context in Palestine.
And following from that, can you tell us a bit more of why the UNHCR is not responsible for Palestinian refugees and you have this separate organ?
Well, there is a very simple legal answer to that. It's because the Palestine refugees are not within the mandate of the UNHCR. And UNRWA was created specifically to provide humanitarian relief to the Palestine refugees, pending a political and fair resolution of their plight and of the current situation of these refugees. So they just have different mandates, and it's not the mandate of the HCR to take care of the refugee in Palestine, and they could not, because the Palestine refugee have a right to return, and that's for diplomats and for politicians to address this issue. And the UNHCR, is having already, I would say, perhaps more than 20 million refugees to take care of, including their right to return, but also their resettlement in different countries. So it's just two organizations with two different mandates.
And my next question, I think you've touched upon it throughout your discussion quite very helpfully, but I was wondering, in terms of specifically to the Israeli-Palestinian conflict, do you believe there are any, or there are specific legal frameworks we have in play that could essentially accelerate sort of the involvement in this issue, or is it going back sort of to the overview and theme of political will in this instance?
I mean, it's always complementary. I've never seen my role as a human rights or international criminal lawyer as a practitioner as in the realm of politics or diplomacy. That's not my job. That's the job of diplomats. As a lawyer, you're focusing on criminal accountability in investigating, prosecuting, defending, but that's two different jobs. And I think that, they complement each other. And I know it's always, it's always a debate, right, between politics and justice, between peace and accountability. I think we do different work. I think we complement each other. And so I will continue. I think for your specific question about the situation in Israel and Palestine, I think diplomats need to do a better job, definitely, but they need to continue to do their job. But in the meantime, it's for criminal lawyer, it's for human rights organization to continue to raise awareness about what's going on in Palestine and Israel right now. And I think, as long as there is not a political solution for that, and as long as, crimes, human rights violation, occupation, colonization continue, we should do our work as human rights defender, as international lawyers. And as you know, I mean, you've said the ICJ has been seized with a second advisory opinion. The ICC is also mandated to investigate and has opened an investigation in Palestine. We should continue. We should continue to document. We should continue to seek justice. And that's the only thing we can do. And then, you know, the diplomats and politicians should continue to do the work. And I think as civil societies, we have to continue also advocate within our countries to push the peace agenda, but also to push the justice agenda. That's extremely important.
Thank you. And I think on that note, that is the perfect way to wrap up. And I just want to say, I think you've addressed so many various issues, but then also opened the door of other considerations of how lawyers and politicians can also continue their work in the investigative process, even though there is certain barriers, as we said, blockage of certain lack of political will and also lack of awareness across the international community. But this has been both a fascinating and valuable discussion and helped strengthen knowledge and understanding and respect to the mechanisms we have in store to establish the accountability for the violations committed by actors under international criminal law and international human rights law. And frankly, all the more why we need to continue to ask these prevalent and difficult legal questions to further strengthen these mechanisms. But thank you again for taking the time. It has been the most humbling experience to speak with you and to learn from you.